And first, I want to say, first and foremost, I gave that picture on the thumbnail because when Ashleigh Merchant begins to tell what I call white lies, is not necessarily a lie, but it's evading the whole matter and evading the truth and sprinkling in and throwing in a little this and a little bit of that. And I have to be fair to Fani Willis when confronting her on the stand. She addressed and called this woman out in her pink dress and said, there are lies that you put in your report. There are lies that he went to the house. There's just lies that she addressed, and she was really upset about the lies. And I know she got emotional, and she showed that she shouldn't have been representing herself and shouldn't have got on that stand. Well, she didn't do it after that. She didn't. She followed good advice and did not get back on that stand. But I do want to give her the opportunity for me to see these lies, and for a couple of black gentlemen that were sitting behind Ashleigh Merchant, and also another gentleman that was on the panel, the Senate panel, a black gentleman, asked her specific questions about how and why she was filing a motion on some specific precedents that she used that were not necessarily precedents that she shouldn't have used. I'll try to find it. I'm going to start it off with this. And it's just right at the part where she's looking at the text message. And I'm going to let you make your own decisions as I scroll through. This is something I'm doing haphazardly, so don't mind me. 30 minutes of this, and I'll get the specific clip if I have to, if it doesn't go into it. Okay? Here we go.
I can't read that green. You don't mind just showing me.
No, of course. It says, is this accurate? And this was again on January.
You're saying, is this accurate? You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he had corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Now, specifically, he's saying where they met. He's real slick about how he answers.
I did not disclose Mr.
But she
Bradley,
used this.
In my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in. Here
we go. 1, 2, 3, skipping a few minutes. Hold on, guys. Now, what she's doing is saying it wasn't a fun position for her to be in, to have to go and do this. And she was very zealous in doing this. It wasn't that it was a fun position. Now, she was very zealous in wanting to do this. So you'll see. Here we go.
To be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified,
somewhat.
That he had never discussed this with me. And
then you showed his text messages where y'all discussed it.
Well, at that point, that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Had told you that?
Yes.
Okay.
He had told her what was on the text messages. He didn't say yes, he testified. He told her anything else. Making that a point, y'all.
Relationship, yes.
Before he was hired?
I
No,
watched
he
the
did not.
whole
So before
interview.
I filed the motion,
So
nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther
Yeah,
King.
walk us through that. What were the grounds that, why is it you feel like Fani Willis should be disqualified from continuing this prosecution?
Yeah, and these are things that I alleged in my initial motion that was filed on January 8th. Um, I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting because I remember hearing
see where
the
she
special grand jury had recommended.
see where she closes her mouth in when she says, I believe allegedly her little white lies. And when I say a white lie, I mean it's tainted with part truths and some magician magic. Anyway, just notice it when that's why the thumbnail is like at the bottom. Her mouth is pulled inward. It's just something I noted when she gets ready to add stuff to the testimony.
Prosecuting like 40 something people.
They have.
He was not even in that list of 40.
He was not.
And they didn't take, or they, as in Fani Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called "Find Me the Votes," that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. And I mean, I have
Is that because they cut deals with them, immunity deals, or?
Some of them are that. Some of them I just don't think she wanted to bother with.
And she added to the list though people that were not even recommended, or at least your client.
My client, yes, she added him. So he was one of the ones. So there were some people, and it's publicly available in that book, like Senator Graham, Loeffler, those Purdue, those people.
That recommended prosecuting them.
Right, she had considered prosecuting them and taking them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, why would you want to expand it? There's different ways you can go about prosecution.
You figure out why they add your client.
There's her mouth again.
No, but the my allegation in my motion is that the bigger the case is, the more money that's made, and that made sense to me. So for me to file the motion to disqualify, obviously we had to have some type of a basis, besides all of the violations, and so expanding the litigation. Because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, follow me down the path, if you only indicted one person and it was narrow, you could try it in a month. If you indict 19 people and 3 different.
So what she's talking about is Fani decided to indict so many people to make more money. So she didn't indict a few people and make less. So she's trying to say the reason she indicted so many people is to make more money. This is a case she's building. This is total, I want to say BS. I don't know if that was the Lord or the Holy Ghost, because it just came to my mind. Maybe it was just me. Anyway.
Actually alleged criminal schemes, like I divided it up earlier, that you now have 3 years of trial. You've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special.
There it is. She said that's the financial motive. Look at her mouth going in. Jesus. Okay, so her mouth turns in when she's adding BS. I want to call it BS because then I won't get, what you call it. Okay, so we'll get back to it. And I just want to say that whenever her mouth turns in, she's added something to the testimony. That's my position on this video. If I get off of here, you can watch it and you can see for yourself. Okay? Here we go. Back to the video.
And you had the data to show that she was financially benefiting from the continued prosecution.
Yes. And so to answer your question, you were saying walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it, and at that point, the world is shocked. I mean, shocked because nobody had any idea. This had been
Who
hidden.
cares about the world being
This was even
shocked?
hidden
Come
from
on,
her
get to your
father, who
point.
She had testified. She talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it.
Of course, she leaked it
Mr.
to the
Bradley,
media
that
to help her
next
case.
weekend, he gets some calls about, he gets a call, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately.
Now he asked her a question about did she file financial records, and this is the story she's telling. She's not even answering his question direct. She's going through all this hoopla. Here we go.
Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fani Willis?
Yes, and I've not gotten it. I've not opened records yet, but I have been told that Mr. Banks also has one of these special counsel contracts. Again, I have not opened records yet, not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County, and he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids.
She's not answering the questions. I want to bypass this.
He took it as.
I want to get to a certain part. Let me see what he's asking.
Did you?
Yes.
And
Yes.
then you started issuing subpoenas to line up your evidence.
Yes.
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
Yes. So, and let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Miss Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially
And the other two special prosecutors were white.
Yes.
But they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, yeah, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit cards. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Miss Willis had been subpoenaed to testify, and she actually invoked her executive privilege as the DA. She would not testify. So then
they settled it.
Right, and then they settled it because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So their response that they filed, I believe it was February 2nd, I believe, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100 on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis. very harshly saying that I was making this up and nobody had told me this and it was, gossip and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried, because I knew they had called and all of these things, but I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly, but that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify?
Yes, sir.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, it is a conflict of interest.
And that's because
There she
the
goes with that
financial
lip.
benefits, or just because?
Mainly the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially
They're
motivated.
using her church speech.
Extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate conduct for a prosecutor.
Very much so. And there's case law on that. There's bar rules on that. So
What is
there
the
were
case
a
law?
lot of public speeches that were made along the way. And, they're you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements.
It was for fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I call it, where she's, calls me and, my client racist, and says, it condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just, it was just nuts. The book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
It came out a month ago, if even. And she.
Here we go. Another commercial. Don't worry about that. 3, 2, 1, and we're done. This is stuff is making me sick to my stomach to watch her. To be honest with you, that's my spirit talking.
When she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that
I don't get a reading of what's going to happen with her bringing this case.
And she's talking,
but I can tell any kind of aspiration she had might be used with the Trump campaign, but as far as political with anybody, probably from the Democratic or Black side of the coin, if they see this, they're going to feel some type of way like I do.
Trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was moved to the state Senate as well, because all of this began on January 8th, which is that the day we started, 8th or 10th or something. It was the day session began, and all of a sudden these bombshell allegations come out, and I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues and whatnot. So I remember she wouldn't testify in the divorce case. But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that,
as they were arguing the motion to quash.
I wonder. Okay, so
there she goes. When she throws in her little stuff, she folds her lips in.
The start date of this affair?
Yes, she said it started in early of 20.
Let's watch for that lip again.
There was some discrepancy between them, a month or two here and there, whether it started. Generally, it was around March. Is what Mr. Wade.
So what are the consequences for an attorney to give sworn testimony that she did? If you're Bradley, what is it, Yearty, your Trackhawk data, your other independent verifications are found to be truthful,
It's a crime. It's a felony. You'd lose your license.
Yeah.
It's perjury.
Same for what?
There she goes,
Yes.
folding that lip in.
And we have rules that are one of the, outside of privilege and confidentiality.
She wants this
we
so
cannot
bad
perform perjury.
outside
So
of
if I have a
anything.
client who tells me I did it, I can't put them on the stand to say I didn't
It's
do it.
a specific want that she
would lose my
has.
license over that. I cannot do that.
And Yurdi came to
Hmm.
court and said, "Oh yeah, this started."
Now
in
listen to this.
2019."
She saw them. She saw them together. She testified that she saw them romantically together, and they were very close.
Okay,
And,
she said, and I wanted to stop it here.
you had Bradley's
She
text
said
messages
she
show he
saw
confirmed
them romantically together and they were very close. When actually Miss Yurti stated, or that's her name, that's the name of the condo, they're calling it the Yurti condo. She stated that she saw them kissing and hugging. She refused to say that because that's probably what Miss Yurti said to her and then got on the stand and said kissing and hugging. But she's not saying this in her testimony that Miss Yurti stated that she saw them kissing and hugging. Why is it that she's keeping this part out? It's because probably it's not true. And Miss Yurti added that on a Zoom call.
absolutely back in January.
Yes, and he had a lot of details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text. What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place.
place.
Okay.
Mm-hmm. Yeah, to her place. There were other things. Just a lot of context. Things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay.
Now she answered that herself, folded her lips in, said he paid in cash so there wouldn't be a record of it. That's a statement that she didn't need to make on her own.
I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now, and I'm not the best person to explain that. My husband argued that part, but appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this.
Here we go. Now she's explaining that she's not the person to give this information, but her husband did this part. And she's trying to explain it to him.
Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor. And we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety. And then actual impropriety is receiving money, receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr.
Watch
Wade
this lip fold in. I haven't seen this part, but watch it.
But there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
no, and we asked her where you got it. She said that she said she borrowed it from her campaign. So
she didn't really say
said
she
the
borrowed it from her
original large
campaign.
sum of cash came from her campaign.
She said she borrowed money for her campaign, and some of that she kept. The money she borrowed,
In that area of law, but that is
not
my
the money
understanding.
from the
Black and
campaign.
white.
So she testified that she took the majority of the cash she had on hand was from her campaign. That a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting $50 back at Publix. But she's giving him $4,000, $2,500, so large sums of cash. So, and there's no trail. Obviously, there's no record of any of that.
Here she goes. Told you. Watch that lip.
Some of the documents you produced to us, there were a couple of IOTA trust accounts.
Mm-hmm.
Those were Mr. Wade's accounts?
Yes.
Okay, so he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes, and so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners. And then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account?
I think it might have been part of the reason that they dissolved.
That they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his home bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right, and he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a personal injury case, and you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You settle, you finalize the case, you send a settlement letter, you get the amount, and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it in your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that
So sometimes
financially they wanted to.
attorneys may take a retainer up
Yes.
front and bill against that retainer. Say, you might do that on some of your criminal cases. So,
Yes.
I'm gonna take $25,000, I'm gonna put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract for Fulton County, should probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that.
ethical violation that can get you disbarred?
They highly regulate the IOLTAs, highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain. But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon, and you've been
Yes.
very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions on our rules.
This is what I want to get
We did
to.
allow at least one member of the minority party to participate, and Senator Jones, you're not time limited. If you, when the buzzer hits and you've got to go to court, you tell us, but I feel like we got at least 15, 20
Oh,
minutes.
definitely do, and I'm happy to answer any questions you have. My court's at 1:15 in Fulton County, so, if I get in trouble, if you can call the judge, then I'm fine.
Okay, this gentleman, before she does this,
Go back to the issue about the.
this gentleman is a Black American gentleman. He is getting ready to break down some stuff that she has in her brief that is totally BS. So I'm going to let this tell you why I did this story, not on behalf of Fani Willis, but to do equal opportunity reporting on this case. This will be the last time I believe that I'll deal with Miss Merchant, Miss Fani, until the judge comes back with his decision. Okay, then I'll get more into other things. But here we go.
Like, I think that's kind of brought us all here to some extent. On one issue, in your brief, the most recent one that you filed.
The second one?
Right.
Okay.
On page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath.
Right.
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed, and in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in the order, but I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right now.
Here we go. This is the part I want y'all to get to. Hopefully it won't take long. He's going to ask very pertinent questions. 1, 2, 3, go. There she goes with that lip too, y'all. Coming in this. She answers him.
And I'm just going to show him while I'm moving on to this next.
It shouldn't have been part of this next motion she filed, but she put it in anyway.
Which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that in some kind of way this creates a conflict of interest. And of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yeah, it's page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
There's that lip.
I'm so sorry. I'm so sorry.
Microphone just closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
Yeah. I want this a little bit more. Okay. So that one there on the Whitworth case, tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24.
She should know this brief by heart.
So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification. Held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially to answer your question, that first of all is physical present only. So,
Right.
yes, and we
But you did cite it.
and said that it's physical present only.
And you're using that as the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth, and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have a case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had, or the prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, and the prosecution also. So, and in that case, that's physical present only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case, so that was completely different. Yeah.
As an amusement, it was a contingency fee case, so they had a personal stake, actually, really in the conviction, because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case, because there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right.
That's not where they get money.
Yes.
They don't get money for bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a
But
conviction.
they only get money if they're the victor. And he's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, oh God, that's a long answer. The actual conflict is lying on your disclosures about how much money.
I'm talking as far as this issue is concerned right here. When you use with worth, you use amusement sales, and they say that
she used that case to try to bring forth her case. And the only way that these individuals wins if they get an actual conviction. Now, she's filing a case using a case like this that doesn't have anything to do with the winning. It's actually the filing and the making money as they go along with the case, because they've spread it out with so many people they're interviewing. And that's how they're getting the cash, she's claiming. But he's saying, how can you use a case like this and bring it in your brief and use it to come against attorney prosecutor Wade, who Fani Willis hired?
there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. And the prosecutor basically said no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. So they said that still is not an actual conflict, even though someone told that prosecutor, we want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial, so it's not limited just to the trial. But to answer the first part of your question, when you're asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end their client's case.
With a $5,000.
But it was going to end. It was normal billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case.
I'm watching this with y'all. This is the first time I'm hearing the end of this. I just saw it of interest.
He went out and said, I'm tired of billing. I'm going to offer misdemeanor.
Okay.
And you said no.
Take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer, so what I was trying to explain, I'm glad you gave me this opportunity to sort of go into it.
Uh-oh, I pushed the wrong button, y'all. I hope it didn't mess up nothing. Okay. He got her under fire. Under fire. Please go back to the same. Here we go.
In a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been handled.
We can't even hear you.
Oh, I'm so sorry.
Just pull it up right to you. Pull it to the edge of the desk if you have to, so everybody can hear.
Sorry. Okay, so how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle. By putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these three different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation because imagine if we just had, like you see in other cases,
So I wonder if she told her client what he was being offered and he made that decision. And a lot of this decision is hers because she's fighting two cases, not just for her client, but to get at the Wade and the Fani Willis prosecution to not expand the cases, and that they're expanding the cases for money. Instead of thinking about her only client, this gentleman that was indicted along with other people that Fani Willis, Nathan Wade are prosecuting in this case, this Trump case.
You can limit the information to just that crime and that case, or you can have three separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have three trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not.
Which one? What word?
Now she takes water. Watch the two gentlemen in the back shaking their head and with their arms folded, looking at her like, this woman is full of crap.
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who was not supposed to, who was talking to him, who's the prosecutor, Hobbs informs Morgan, who was the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying, this is the case you cite. Well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so therefore, the case that you cite is totally opposite than what the situation that you're dealing with. How would you say that you have a conflict in this case based on this case? Just saying, just based on this case. That was your first case that you cited in your brief.
I don't think it was actually the first case, but
The first was actually a federal case, but the first Georgia case you cited was Whitworth on this particular issue.
right, on this particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got is we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple of months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is
Who actually brings the case?
the district attorney. Well,
How did they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So he's the one that he presented most of the witnesses,
How was your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so grand jury.
Yes.
Okay, so we had a special grand jury, and then we had a grand jury
Yes.
who made this determination.
Well, yes.
They made a determination to bring charges, basically, to indict, correct?
Yes, and I.
So are they part of all this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is
I like that
the
brother
witness
shaking his
comes,
head in the
and
back.
In this case, it was actually the investigator for the DA's office. So just understand this: it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a
Shaking
lawyer
his
that I worked
head.
with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident, and the grand jury indicted him.
You're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the grand jury.
Wow. His brother is too sharp for Miss Merchant. These are the white lies that I'm telling you about that Miss Merchant is bringing back to him. Evading the question. Back to it, y'all. Thank you for tuning in. Appreciate you. Let's get to it.
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. And they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment and then they vote and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So it went to a special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3
And
already.
they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents. He's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career, and I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualification. So,
Yes.
but you did mention early on that
And he is
very
qualified.
Instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising that he's able to go to a special grand jury. You say he's integral
Well,
in
that's
that.
not surprising.
And he's going to a grand jury, and you say he's integral in that. Then why even say that he's unexperienced and he's getting people to plead guilty? But basically, you're saying those are just lawyers that don't want to do anything anymore. They just plead their clients guilty. I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they brought this case to this particular point. Very complicated case, I imagine.
I mean, that's something that we can debate. You know, if walking someone through the grand jury, the special purpose grand jury is complicated or not. You know, asking questions, and again, there's a team of 10 lawyers. So
that's a team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and, you know, restricted in their private law practice? Why do they need him there when there's all these other people?
And why not him?
Asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent. There's no adversary. There's no judge.
Once it became adversarial, you've had persons start pleading. And maybe more potentially correct, possibly. But we'll find out. But let me ask you this, though, because you were talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office would basically shut down. There's a potential that the DA's office had actually basically shut down.
Oh God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you had 5 new inexperienced ADAs, they're not tackling this case. And also,
well, the inexperienced ADAs are not going to make $100,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job
that mouth.
you're talking about that you're going to hire with that, meaning that you're to pay him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could use this money for that. But that money was delegated for him on the short term project, so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified, what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, it's delegated to him because that contract can end at any time. She could say, "Hey, the contract," because he works.
Do I go on for you guys? I'm going to give you about 10 more minutes and you can pick it up on any of these stations, CNN 18, probably Fox Atlanta. Let's go. Just want to keep y'all abreast and have this balanced. Okay, give me some likes if you have watched this all the way to the end.
Oh, yeah.
So that contract can actually end at any time. That
Yes.
would be the point.
Yes.
On the trips, how much total were the trips?
About $20,000.
And I think about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
You know, unfortunately, they did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you, most of it was paid in cash, so there's no record. So I wish I could tell you, but
going by your slide, one was 3,335, one was 4,453.
She avoided that question, but he's naming what she put up there.
Trips.
okay. But which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then we see the next one, and then the next two. How would that compare? I mean, why is that so unusual on price points as far as trips are concerned?
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had two cabins. His mom had a cabin. They had an oceanfront balcony. You know, for Bahamas, I think oceanfront balcony is probably, you know, upper middle, but I don't know that it matters.
It don't matter, but you mentioned it.
But not unnormal for a lawyer. I mean,
You know what maybe the average American spends on a vacation?
not this much.
You don't think?
No.
Have you looked?
No, I haven't, but I would imagine. most of
She
the
haven't even done the
taxpayers
research.
Would love to go on any of these trips.
Well, you know, if you, since you speculated, well, I could speculate and say that you did look, and that's why you didn't put it in your brief,
I did.
because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of four, well, at that time, they were taking 2 and 3 at the time.
That makes
So
sense.
that makes,
But
that's
these, no,
about
no,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said 3,700 for a family of 4. That does not surprise me. For families that can already go on vacations, does not surprise me.
So it's basically what the average American would do.
There goes that
So
lip.
that's,
Yes.
this is half of that for 2 people. So you said 3,700 for a family of 4. This is for 2 people.
Right, it's just 2 people.
Right. So
Yes.
that,
And a family of 4 usually will have maybe 1 or 2 cabins.
Bottom line is, it's not extravagant. It's not lavish, is it?
the law only says $100. So
But it's not lavish.
that's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas. I didn't include that. I didn't want to do the math, and I also did not want to.
To her credit, she didn't include Ubers.
So your argument is that a person who makes $200,000 a year
Mhm.
is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. That's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So, we did
What else
argue
is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can
What
kind
an
of assume
Uber has
she
to
was
do
from
with the
airport to
briefs.
the hotel, but I did not
See
want
how
to
she gets
speculate about it.
off?
So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are on
That's the same
the
brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we have.
Exactly. That's what I
That
had.
person
Yes.
is doing all of this for that.
Right. Oh, yeah, and
Understand.
so what I included was what I had the actual hard proof of, and then some of it's attached to the brief, some of it I got by subpoena, so some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted, and there were a lot of other receipts that I had that I did not know for sure if they were joined, and so I didn't include those, and I haven't
You
talked about it
should,
today.
correct?
Exactly,
That's
I
correct.
100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then becomes,
No, she hated to get in front of him.
going to conflict as far as his salary is concerned. Just curious, is it the amount of salary that you really creates the conflict? I mean, because we get stuck on money a lot. So is the amount of salary that is creating this conflict in your mind?
No,
No, or
it's
it's
the
just
fact
the
that
fact that he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Miss Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
Which we just discussed.
That's the biggest point that she
If
has.
it's not a trip, then you don't believe there's a conflict.
Oh,
If
I
they
do,
didn't have
because of the Fulton
trips.
County laws. The laws say that they
I'm
can.
not.
Wow. I'm glad I kept this on for y'all.
What the case law says, which is
Oh, yeah.
what the judge is actually going to. If we're not hiding that or against the Fulton County ordinances,
They
do
weren't
you
hiding it,
believe,
no.
do you believe that there's a conflict? If they brought it out and said, hey, we're dating, is there a conflict in your mind?
They only brought it out once I alleged it.
And it
they
wasn't,
called
it
me
was
liar.
private. It
What I'm
wasn't
saying is that they brought it
they
out,
weren't
there's
bringing out
conflict in your mind.
If
Is it a
they-
conflict?
for anybody's
If
business.
they're in
And
there-
she
there
stated
was not a
that, Fani
conflict.
Willis,
So
on the
in a
stand.
perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm gonna go on vacations with him and we're gonna date and we're actually gonna go home to the safe house that Fulton County's paying for and he's gonna be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
So then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict.
So
it's
that's
still
why she's
exists.
bringing the case.
If you,
Oh God, I think I messed it up for y'all. Sorry.
What can you do
No, I
with dual
didn't.
fiber 5 gig?
She's bringing the case because she's trying to say her client has a conflict, but really it's a personal vendetta. Just hold on, guys. Let me bring it back to you. Oh, I'm sorry, y'all.
if you have an actual conflict where your client is harmed, Just because they disclose it doesn't end that conflict. So
No,
what you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You
no.
just could. If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place,
Mhm.
because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have an actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand your question to me. I don't know what
You
you're
don't
asking.
have a conflict if you're saying if she disclosed it, it would go away. Then there is no
No,
conflict.
no, no, I did not say that. I said we would not be here if that had happened.
Right, because you wouldn't claim there was a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it. But if
she
it was
disclosed the
disclosed,
facts, hold
it's
on.
disclosed
If
now,
she
what is the
disclosed
conflict?
Undisputed facts, the facts that we all, your side and my side.
How is your client harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if all the undisputed facts, if those had
Oh,
been
I
in
feel
front of the
sorry
Board
for
of
her
County
now.
Commissioners, we wouldn't be here because there would not have been a contract, because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners
Why
known
should
all
he
the
have not
facts of
been
the case,
appointed?
he would never have been appointed to this case. So
And
we
he's a
can't
good
now
prosecutor. I saw
speculate
it.
as to what
And
could have happened.
what case law do you point to prove that?
The statutes. It's
Not Fulton County State. I'm asking the Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And it's not.
no, and it's really not surprising, honestly, because can you imagine this happening? I mean,
It
honestly,
happens.
in December, would you have imagined this happening? I think most people wouldn't
All
have.
sorts of conflicts are taken up by the Court of Appeals.
I can tell you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not
Is she
filing.
paying him, or is he earning the money because he's actually
Doing the work.
hours because he's prosecuting the case?
I don't.
He's
I
billing
wasn't
hours
there.
because he's prosecuting the case, correct?
I
The case that a
assume.
grand jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very
That
regular.
is the
but
deal.
I
The
don't
proof
know.
is in the
So,
pudding,
you know,
honey.
Those
That's what
numbers
we
do not
say
make sense that
as
she's just
Black
paying him
Americans.
in
I don't know
that
if white
sense.
Americans say that too.
He's earning money.
But if
for
you
the person
don't,
he in charge of prosecuting.
my white
that grand
American
jury
followers, the proof
and
is in the
that's what we
pudding
are.
is the
You're
same we've
correct.
had since I was a
She is not
kid.
paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists, one hundred
Employees, yes.
percent, and that he is part of that process, and he is prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution, and you said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Oh, that lip. That's what she calls integral.
I just had one last
Necess-
question.
necessary.
The case that you cited, it clearly says
Which case? I'm sorry.
in Whitworth
Whitney.
versus State, it clearly says the prosecutors receive no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Nice.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people on visual. I like to see it. Thank you.
While she's looking at this, we're gonna wrap up here in a few minutes. I wanted to let the public know how you can get information to us.
Okay, I'm gonna cut it off here, y'all.
Email address for committee business.
Gonna cut it off
And it's
here,
simply the
y'all.
last name of the senator. In my case, it would be Cowser.inv. at senate.ga.gov. INB obviously for investigation.
He's giving you information to send
So
to
you
them if
send
you're
her the
interested.
last name dot
Let's see how long this
INB at
is.
senate.ga.gov.
Wow, look at that.
And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will
So if you don't watch this, this is news18.com. News18.com.
Reached out and wanted to provide
CNN News 18 from 2 days ago. Wow. I just feel bad for, I don't feel that bad because people get what they do to other people on purpose. So I really don't feel bad. So let me just sum it up here. Let me just sum it up here without getting on. My phone is ringing. Let me sum it up here. I have a 2:00 meeting. Without getting on a long tangent, this is the broader side of what is happening with Fani Willis. And I can see why a lot of Black people from churches and wherever else are rallying behind her. Church is supposed to be a place of forgiveness. So it's nothing wrong with a lot of churches getting behind her if she doesn't have the support. How are we Christians if we don't have the support? On the other hand, I understand where churches will come against it and say, why are you using the pulpit to discuss this? I'm part of that group that says, I wouldn't do that. I would probably, if a church allowed me to come and speak my piece, and that's the only place I found safety, I would probably stand on the floor. I wouldn't use the pulpit and sound as if I'm bringing a message. So I think she kind of made some mistakes there. But Fani Willis and Nathan Wade and Attorney Bradley are all involved in this case. Ashleigh Merchant brought it. These are people that were indicted in the Trump case by the prosecutor, Nathan Wade, who she got a romantic relationship with. She had this romantic relationship. They're trying to prove that it started before November 1st of 2021. I don't know, and nobody can really say that I know of when it started, actually, because right now the judge is taking 2 weeks to decide if they're going to pull them off of the case. And I guess further, if she's going to lose her license, I don't think anything will happen to the prosecutor personally, but I think they're going to have some damage control. And I think it's some things that are going to happen with the DA, Fani Willis. And I think that some of these, her 95% conviction rate is because she prosecuted cases she could win. And she prosecuted cases with this RICO. I got one of my videos on a RICO she did 8 years ago. It's very interesting. Please check that out. Attorney Adams from the Young Thug case with Brian Steele. Attorney Adams, who represents Young Thug along with Brian Steele, is on that case from 8 years ago. And she prosecuted teachers actually helping with test scores. And I won't tell you my personal opinion on that because that is another story. I want you to look at that case first. Put some questions on there for me and I will bring it up again and we can talk about it. Okay? I'm signing out. This is Graceful Exposure. Thank you for listening. Bye.